Last week, when the Law Reform Marriage and Divorce Amendment Act 2016, Act 164, was taken off the priority list to be debated and was placed last in the Parliament order paper, I immediately objected to this careless decision of the people in power. Generally, this means the bill may not be up for debate and could be killed off. Yesterday, the Perak Mufti, Tan Sri Zakaria, urged Putrajaya to withdraw from tabling the bill due to a controversial provision banning unilateral conversion of minors. He was reported to have claimed that the proposed amendments will deny the rights of a Muslim convert, in addition to sidelining the powers of the Sharia courts. The Perak Mufti was reported to have said that the bill on Act 164 regarding married couples where a convert weds a Muslim and there is a divorce, then the children cannot be registered as a Muslim either by the mother or father except by consent, both after the child reaches 18, is a very serious matter that is against the Constitution and furthermore against Islam and is opposed to the rules set out by the Sharia. He claimed that any law that is against Islam is a direct opposition to God and will constitute idolatry. The Mufti's statement was most shocking. First and foremost, Act 164 regulates those who are registered their marriage under the Civil Law and Civil Marriage Act. A Muslim cannot register his marriage and let alone seek protection under this Act. The Act governs the affairs of civil marriages born of a non-Muslim. In simple terms, it has nothing to do with the Muslims in this country. Further, the amendments have three important pillars in them. Among them, religion of child. The amendment proposes to put in law the cabinet decision of 2009 when it was announced that a party to a civil marriage converts his child, the child would be brought up in the faith the child was prior to the parent's conversion. If the amendment comes, it is 8 years too late. When I first brought it up in 2009 May, it was an assurance given by the cabinet, and de facto law minister Dan Nazri made a formal announcement in Parliament saying the necessary amendments will come into being very soon. Very soon, 3 law ministers have come. It is still not so soon. Second issue is property of spouse after conversion, clause 5. A married person, if he converts to Islam and subsequently dies, his property, if any, would be shared by both parties. This is a fair clause because before this amendment, the present law is if a convert becomes a Muslim and then he dies, all property will go to the Muslim wife. This is an unfair part of the law in this country for many, many years. I have filed cases in court to challenge this, but this provision was another positive movement. Finally, clause 8, the parent is duty bound to provide financially for the child till he finishes further or higher education or training. Presently, the obligation ends when the child attains 18 years old. All the above proposals are applicable only for those who have registered their marriage under the Law Reform Act. Is the Mufti suggesting that a convert can take shelter and avoid his obligations to pay his ex-wife and children the moment he becomes a Muslim? Surely this cannot be the case. Further, the Perlis Mufti, Dr. Asari, has recently said children should not be forcefully converted to Islam, which statement speaks well of Islam. On November 21st last year, Tourism and Cultural Minister Dato Nazri has said that the proposed amendments to the Act, which will end unilateral conversion of a minor to Islam, is good for the religion. I don't want Islam to be used by a tool of people to get out of their responsibilities towards their spouses, he said. Hence, a deeper understanding is needed by people like the Perak Mufti. The bill is still listed last in the order paper. I hope common sense will prevail on all. For the betterment of all, the bill with the 3 cardinal issues, among others, must be approved in this session.